Thank you for staying with us. Now, one of the big stories of 2024 was the arrest of Safa President Jordaan and his co-accused with charges of theft as well as fraud to the tune of 1.3 million rand. Now, that happened later in the year, but the matter started long before then. My colleague Benjamin Leshoro takes a look at the events that led to this massive story and what followed next.
The 8th of March 2024 will forever be remembered as the day that sent shockwaves and made headlines across the country. It was on this day that the Hawks conducted a search and seizure operation at the South African Football Association headquarters in Nasrec and announced that an investigation into certain top officials at the organization was underway. On the same day, the association came out swinging, condemning the raid, in which a few electronic devices were seized, calling it unlawful, unfortunate, and a shame to law enforcement agencies. It took months before South Africa could finally know the outcome of the investigation, and when the country finally did, it was big. Arrest warrants were issued against Safa President Jordaan, CFO Groni Hluyo, and Grid Communications boss Trevor Nyethling. The charges against the three were related to a 1.3 million rand fraud and theft scheme, with a PR company allegedly brought in to boost the image of Jordaan following the rape allegations some 7 years ago. On the eve of their arrest, it emerged that they had filed an urgent application at the High Court to have the raid in March declared unlawful and set aside in a last-ditch attempt to block their impending capture. Fast forward to the 13th of November, the three were arrested and made a first appearance and bail application at the Special Commercial Crimes Court in Palm Ridge. Bail was set at 20,000 rand each, but it was the issue of passports that took center stage, with Jordaan, accused number one, the only one allowed to keep his travel documents, provided he only uses them for official business as Safa president, a position which the Federation stated they would not remove him from. The trio would return to court on the 5th of December, with more legal questions raised related to the matter. Advocate Norman Arendse made his first appearance as Jordaan and Hluyo's representative, and the state made it clear that they planned to challenge that, saying he's conflicted, having done work for Safa previously. On their return to court on the 10th of December in a marathon sitting, the first issue on the agenda was Arendse's involvement, as prosecutor Moahi Malebati presented the merits of their application.
The state has been informed that the said counsel is the appointed legal representative of Safa, the respondents, in the Pretoria High Court case number 037466 of 2022. The said counsel has prepared and filed the respondents' heads of argument in the said High Court matter in the application for leave to appeal as recently as 26 April 2024, and the Annexure 1 is the said respondents' heads of argument, which is attached here to your worship.
In his response, Arendse tore into Malebati's integrity before delivering the knockout blow of jurisdiction.
And I say that with the utmost respect, does this court have jurisdiction to bar you from the two accused exercising their constitutional right in terms of Article Section 35(3) of our Constitution to a legal practitioner of their choice?
The defense then drew first blood, with Magistrate Shirley Soko declaring that her hands were tied and dismissed the application.
So when I'm saying that, if I have to tamper with a right that is governed by the Constitution, as I'm a creature of statute, I would say in terms of the constitutional law, I don't have jurisdiction to deal with that aspect. It has to start in the High Court. So in that instance, by so saying, I would say that I'm going to allow the advocate to present accused 1 and 3.
Eventually, the court listened to the second matter of the day, the application by the defense to have the matter struck off the roll, citing unreasonable delays due to the pending High Court application relating to the raid at Safa House in March.
The main relief that we seek, my lady, is that the matter be struck from the roll and that the prosecution of this case not be resumed or instituted de novo without the written instruction of the NDPP or the Provincial Director of Public Prosecutions. We also ask in the alternative for costs as a result of the unreasonable delay, but it's not something that I'm strenuously pushing for.
High Court case number.
Opposing the application, the state denied that their case rests solely on the evidence gathered at Nasrec, as suggested by the defense.
Applicants claim that the state's case is solely relying on the said evidence is misplaced and should be disregarded. In as far as the second motion application is concerned, that is case number 2024-130713. In as far as it is concerned, it is my submission that this should also be disregarded as it is dependent on the first motion application.
Meanwhile, the case has 4 respondents. Accused number 2 is Trevor Niesling and accused number 4 is his company Grid Communications as a juristic person. Accused number 2 and 4's legal representative, James Ndebele, maintained that his clients are just caught in the crossfire in a turf war between Safa and its disgruntled former employees.
The charges arise out of factionalism within and outside the South African Football Association, in particular, persons holding gripes with the first applicant, namely Dr. Jordaan. The second and fourth applicant have since been subjected to public humiliation, prejudice, and public condemnation.
In the end, Magistrate Soko poured cold water on the application, saying High Court matters do not affect what happens in this particular court.
I must say that I've investigated the matter the whole day, starting with the first leg. Have you established the delay, Worship? I have not identified the delay, taking into account that the matter just started in November. So there is no delay. And this court also has no jurisdiction to stay the prosecution. On that basis, I'm saying that Section 342 capital A, it is premature in these proceedings, and this court is dismissing the application.
The matter is postponed to the 7th of February 2025 as the defense regroups to get further instructions from the accused on the way forward. 2 days following the last court appearance of the year, the Sport, Arts and Culture Department made a big announcement that they had offered Safa an advance on their 2025 grant. This was said to be towards the outstanding payments of match fees for Bafana players who have allegedly not been paid for a few appearances. The catch? The association must furnish the ministry with the details of their books and financial records and exactly how it happened that their taps ran dry. For Newzroom Afrika on Channel 405, I'm Benjamin Leshoro in Johannesburg.